Oyez, oyez, oyez. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Okay. Good morning, ladies and gentlemen. Welcome to the Court of Criminal Appeals, Eastern Section of the July docket here in Knoxville. My name is Robert Montgomery, and I'm going to be serving as the presiding judge. I'm from Sullivan County. To my right is Judge Tim Easter, who is from Williamson County. And to my left is Judge Steve Sword, who is from Knox County. We will have, I think, 4 cases this morning, and then we have 1 this afternoon. Each party will get 20 minutes for oral argument. If you're the appellant and wish to reserve any time for a rebuttal, please let us know. Of course, the clerk will be keeping time, and you'll receive notification as your time expires. Now, Mr. Clerk, are there any preliminary matters that we have this morning?
No, Your Honor.
Okay. Would you call the first case then, please?
Yes, sir. State of Tennessee v. Dallas Tomes, Jr.
Morning, Your Honors. Kendall Jones from the Appellate Division on behalf of the appellant, Mr. Dallas Tomes. Judge Montgomery and Mr. Clerk, may I please reserve 3 minutes for rebuttal?
Certainly.
Thank you, Your Honors. Mr. Tomes has raised 2 issues in this direct appeal from his judgments of the Bradley County Circuit Court. Both of those do not deal with the actual underlying trial itself, but are rather somewhat procedural in dealing with the interstate agreement on detainers and whether or not the trial court erred in not dismissing his case because it was not timely brought within the framework provided by that statute. And second is a sentencing issue, namely that the trial court erred when it sentenced Mr. Tomes as a career offender based upon convictions that he had, all of which were out of the state foreign jurisdiction of Florida. Although the trial doesn't really factor much into the court's analysis here, as the Honorable John Everett Williams used to say, for the folks at home, I'll give a little brief recitation of what actually brought us here today. In January of 2020, the Cleveland State Community College was broken into during the Christmas break. The building that was broken into was what's called a business incubator. There were several small businesses that were trying to get on their feet, and they offered rent to those businesses at a reduced cost in order to help that. Mr. Tomes broke into that building, took some items of value, damaged some of the door frames, and was arrested pretty quickly and indicted in the summer of 2020. Sometime in the fall of 2021, the Bradley County DA's office sent a detainer letter to Mr. Tomes, who is serving prison time or prison sentence in the state of Florida, informing him if he wished to dispose of that particular case, then he needed to fill out and return some forms, and they would get him up to Bradley County for dispensation of his.
Is that document in the record?
The forms are in the record. I think everything this court needs to determine whether or not the trial court erred, as we argue in applying Article 3 versus Article 4, are there. Now, the actual documents that Mr. Tomes sent to the Bradley County Circuit Court Clerk's office that would have initiated those proceedings are not in the record. And as I averted my affidavit for the motion before this court, I called the clerk's office and they didn't have it.
So that's the document that's missing.
Yes.
Is his response to that initial?
I believe that, and I will brag on the Bradley County DA's office. The assistant DA was very helpful in getting those forms to kind of determine what actually happened in going there. Ashley Zapata, I believe is her name, so very good praise for her. But that's what's missing from the record. The actual, because it has to be sent from the warden of the institution where he was staying to the DA's office and the circuit court clerk's office. 2 different forms requesting dispensation of his case and then waiving extradition in order for him to be brought there.
So there's no question it was the state who initiated this whole procedure with this request to the Department of Corrections of Florida?
I would disagree a bit
Okay.
and change it slightly. The state sent Mr. Tomes notice that he had unresolved cases. So as you all are of course familiar, defendants oftentimes have different cases in different jurisdictions, and it benefits them to go ahead and get those cases out of the way while they're serving another sentence. The DA's office in this case sent him a notice that if he wished to come, that he would have to fill out the attached forms. And the attached forms, or at least the one that the DA's office submitted as part of the record and its exhibit on the motion to dismiss hearing, indicated that they were proceeding under Article 3 and that this was not them forcibly extraditing Mr. Tomes. This was Mr. Tomes' decision to come to Tennessee to dispose of his case. So I don't think the record is too unclear that Article 3 applies rather than Article 4. I think the real issue for this court is where the responsibility lies between the defendant to let the trial court know what area of law it's proceeding under, particularly when it's our motion to dismiss that the trial court was hearing, and what responsibility of that is the trial court in order to make sure that it's applying the appropriate law. Because defense counsel at the motion to dismiss hearing did agree with the state that what we argued the wrong article applied, that it wasn't 120 days, that the state had 180 days in which to bring the case to trial.
Are
And-
you taking a different position now on that? Do you agree the state had there was a 180-day period?
Yes.
Okay.
Yeah, there was a 180-day period for the state, yes, Your Honor.
Okay.
And as counsel for the state has pointed out, one of the things that's missing from the record is that document that you mentioned, Judge Easter, that shows when the Bradley County Court Clerk's office was served. Because the timeline for the 180 days starts when both the DA's office and the clerk's office have been served. And counsel for the state pointed out that date at minimum would be November 24th of 2021, and 180 days from that time would be the day before trial commenced. And Mr. Tomes filed his motion to dismiss before that 180-day period was up. So if this court determines that the trial court was responsible, even though both parties agreed with each other that it was Article 4 that the state requested disposition of it and 120 days applied, which the trial court then analyzed under the framework, trusting in the attorneys who were before him that they were bringing the correct law. Yes, Judge Montgomery.
There was a trial that was set before that 120 days, but it was continued?
That's correct.
Okay. Now, I assume you probably dispute as to whether or not there was an agreement to continue, too.
I think Judge Freiberg reviewed the record and determined that there was counsel present and there was at minimum an acquiescence to the continuance.
Okay, so that's not an issue
no.
as far as you're concerned? Okay.
No. So as far as we're concerned, that we argued in our brief, the analysis would be first acknowledgement that the trial court erred, and to what extent the trial court actually erred in relying on the attorneys who were before him to present the correct law, and then analyzing under that law. I don't think there's much question that it should have been 180 days. That was the timeline. The question for this court is to what degree Mr. Tomes agreed to that, or whether or not the trial court was responsible for the error, and then what we do if there's a remand or something to do with that in light of the fact that the 180 days would have ended right before trial. We argue that this would need to be remanded because the record does not contain everything that this court would need to definitively determine whether or not that 180 days was up.
So
And whether or not this...
Even if I understand what you just said, even if we decide, and it sounds like there's an agreement now, that it was 180 days was
Yep.
the proper time, the trial started on the 181st day?
Correct.
So we're talking about one day?
Yes.
Okay.
Yep. And the language of both Article 3 and Article 4, which the only difference between those is whether the defendant requests to be extradited or whether the state forcibly extradites the person. Both provide for the trial court's determination of good cause if it goes outside of that. So this court would also have to consider whether or not the trial court's original finding that good cause was shown because Mr. Tomes acquiesced to the continuance, whether or not that would still stand, and in light of the fact that considering the state had 180 days to bring the case or not. So, yes, Judge
I was
Horde.
just going to say, so really what you're arguing, I believe, is that the trial judge gave 70 days credit, and basically he was thinking we've tried it at a day 111 instead of 181.
Yep.
And so you're saying that there really isn't enough in the record to determine that the trial judge could make that determination. Is that correct?
Absolutely. I think the real question for this court here is there was error, but whether or not it was to the degree that Judge Freiberg made the correct determination and his analysis applies and is good for the 180 days. Because it is, the IAD language is pretty strict. I think one of the cases that we cited, maybe when the 180th day fell on like a Sunday or something and it had to fall on the Monday, that's room for leeway and something like that. But the real question here, I think, is whether or not Judge Freiberg's logic can continue to the 180 days here, or whether or not, even absent that document that shows when the timeline begins, it makes sense to remand because 180 days from that earliest date would still be the day before trial. And if the court doesn't have any further questions on the interstate agreement on detainers, which I'm now intimately familiar with, but was not when I was a trial attorney, I'll move on to the sentencing consideration. And I do need to update this court since the state and I have finished our briefs. There has been a court case by this court, Judge Greenholtz authoring, that kind of gets to the heart of the issue of our foreign convictions test. So Mr. Tomes all of his convictions were out of the foreign jurisdiction of Florida. And of course, as this court is aware, when that happens, in order to determine sentencing range beyond a reasonable doubt, the state has to show that those convictions at the time of conviction would have been felonies, or what degree of felony they would have been in order to apply the appropriate range. In this case, Mr. Tomes had some 11, I think, convictions out of Florida. The trial court did not perform the foreign convictions test. That said, Mr. Tomes' counsel agreed that he should be sentenced as a career offender, and we have raised this under plain error. The case to which I'm referring is State versus Roy Gerens, in which this court found that there's a difference between, I think the point behind the opinion was, if the defendant agrees to the range, to what degree the trial court is still on the hook to make an independent determination as to what kind of range there is. I think the opinion in Roy Gerens, and that's W2023, it's out of the Western District, W2024-00258. And in that case, we made the same argument that we're making here, that it's under plain error, and that clear and unequivocal rule of law was breached, and the Court of Criminal Appeals found that it was not. The trial court, there would be a distinction between if the parties agreed on range and then the trial court sentenced at a higher range. So if they agreed that he was range 2 and the trial court instead sentenced Mr. Tomes' career, and that was not the case here. And I just want to point that out. That case was decided after we finished the briefing, but this court has taken the position that, as is applicable in this case, if the defendant agrees to range, then that factor of the plain error review cannot be met because they've agreed, and once that is determined, the trial court's not on the hook anymore for making any further analysis as to whether range is actually correct.
So you admit then that this case today is not distinguishable from the
No,
Garin's case?
no,
Okay.
no. At the core of it, they're both foreign convictions. They're both acquiescence of trial counsel, and then the trial court proceeds, as defense attorneys mostly hope that they'll just go ahead and agree with what two reasonable lawyers have brought before it, that Mr. Tomes was to be sentenced as a career offender. We would, of course, we've disagreed in our brief, which was written in April before the opinion came out in May, and said that they needed to perform the foreign convictions test, and we've outlined the reasons for it, that the names didn't exactly match, that would have necessitated an analysis of the factors to determine whether or not they were on par with felonies in the time at Tennessee. And then in this case, because there were 11 of them, I think that would, if the court does decide that there was error and to grant relief, I think that would be something that needs to be remanded to the trial court because of the number of convictions that were at stake, and there's a lot of different analyses that were required. I think it's more proper for the trial court and for the state to have the opportunity to bring law before the court to show whether or not those elements matched with Tennessee offenses.
Well, you were the lawyer on that case. Has a Rule 11 been filed
Garen's, no, Your Honor, the mandate issued, I think, this week.
this week? So,
Spell that last name.
Garrens, Roy
I think,
Garens Jr.
the state filed a letter yesterday with a case attached to it, so we have it in our email somewhere, or the clerk has it. Let me make sure I understand then. Are you conceding the argument, or do you still want us to address it?
I
in
would
our
still like
opinion?
for this court to address it, but
Okay.
I think it would be dishonest and remiss as an officer of the court not to bring very relevant law before this court in order to make sure that the Court of Criminal Appeals is unanimous in its application of the law. And if Your Honors don't have any further questions, I'll cede my time on the floor to the state.
Good morning, Your Honors. May it please the court. Garrett Ward on behalf of the state of Tennessee. Your Honors, this court should affirm Mr. Tomes' convictions on multiple counts of burglary and theft because he has not demonstrated that the trial court erred in denying his motion to dismiss based on his allegation that he was not timely prosecuted according to the interstate agreement on detainers. Similarly, this court should affirm Mr. Tomes' sentences because the trial court did not err in accepting the agreement of the parties below as to his sentencing range and offender classification. Your Honors, on the detainer issue preliminarily, given sort of the scarcity of detainer issues coming up before this court, I think it's helpful to briefly talk about the IAD in general and then specifically talk about what happened in this case below. So, running through at 100 miles an hour, Your Honors, the IAD provides sort of a framework for prisoners who are being held in one state but have pending charges in another state to have those pending charges in this other state, in this case Tennessee, to have them dispensed with so that they're not serving a sentence with sort of the specter of pending charges looming over them without knowing what's happening. Under the IAD, there are two sort of, I'll call them paths that a case can take, and they depend chiefly on which entity, the state or the defendant, requests that he be transported. If a defendant requests that the transport occur, this is an Article 3 proceeding, and under Article 3, and the entire IAD that I'll be discussing today is 4031-101 in the TCA, but it's one very long statute with a number of articles. Under Article 3, the state has 180 days to bring a defendant to trial from the date that both the district attorney's office and the trial court have received a set of paperwork from the defendant requesting this final dispensation. Whenever both of those parties have received this paperwork, then the 180 days starts running. Conversely, if the state requests, then the state has 120 days to bring the defendant to trial, and this time period begins running not from any notice from the defendant because it's the state requesting it, but from the date that the state gets actual physical custody of the defendant. And 5,000 feet, the difference between these two pathways is a difference in length of tolling, of limitations period, and a difference in sort of triggering event for these periods beginning to run. Below, Your Honors, when the defendant moved to dismiss on May the 3rd of 2022, all parties agreed before the trial court that this was an Article 4 proceeding and that the state had a 120-day limitations period from the time the state received custody of the defendant. There's no other way to read the record of the dismissal hearing, which is, I believe, volume 11 of the appellate record before this court. Both parties are very clear on sort of questioning from the trial court about what type of proceeding this is. It's an Article 4 proceeding. It is a 120-day limitations period, and that begins to run from the date the state got custody of them. That was what the parties told the trial court the case was about. On appeal, the defendant has shifted and now says this isn't a 120-day period like I said below and like the state said below, but that it is now a 180-day period, and that the triggering event isn't when you got custody of me, but it's when you received certain pieces of paperwork from me. And Your Honors, that's why we're here before this court on plain error, because the defendant has really sort of changed the legal ball field we're playing in by changing which article of the interstate agreement on detainers he's invoking. And given that we're under the plain error rubric, I think the first problem the defendant runs into is it's not clear in the record whether this should be an Article 3 or an Article 4 proceeding. As I just mentioned to the court, both parties in open court unambiguously represent to the trial court that the state requested the transfer, and that therefore we're in sort of the Article 4 context. Admittedly, though, there is other paperwork in the record, namely a document on the 13th page of the technical record entitled, I believe it's Acceptance of Offer of Temporary Custody. This piece of paperwork suggests that it wasn't the state, but that it was the defendant that requested the transfer. So I'd suggest there's some lack of clarity in this record because we have parties in open court representing one thing, and then perhaps some suggestion in paperwork that we're dealing with this other portion of the interstate agreement on detainers. But what we don't have in the record is the actual triggering paperwork that would conclusively sort of speak most directly to which article we're invoking. We don't have some document would have to have been sent. Either the state would have to have requested he be transported, or the defendant would have had to have sent paperwork to the state. One of those things happened in this case, Your Honors, without any doubt, but that document isn't in the record. So I'd suggest that there's just a lack of clarity in this record as to what actually occurred below, and that's a problem for plain error purposes. But even putting that aside, Your Honors, let's assume that, let's sort of read the record almost in the light most favorable to the defendant. Let's assume that the record does show, as he now asserts, that this is clearly an Article 3 proceeding. His claim fails because the record conclusively demonstrates that the state timely brought this under the interstate agreement on detainers. Your Honor, as I mentioned, the defendant moved to dismiss his case on May the 2nd of 2022. To the extent the record conclusively demonstrates that this is an Article 3 proceeding, it does so via this acceptance of temporary custody form, which unambiguously says the state received paperwork from the defendant on November 24th, 2021. So the defendant moved to dismiss for a violation of the interstate agreement on detainers 159 days from the state receiving notice from him. And then as soon as his motion to dismiss was denied, the state brought him to trial the next day, which would be the 160th day of this time period. The time period would, of course, be told while the trial court is actively litigating the defendant's attempts to have his case dismissed. I'll admit, Your Honors, that I didn't necessarily expect to hear much discussion today of Judge Freiberg's other findings on continuances. Those would be more relevant if we were dealing with the 120-day custody period, because the record suggests that the state received custody of the defendant in the last week of 2021. So 120 days from the date the state received custody was prior to the defendant filing his motion to dismiss. So given that the trial court and all the parties thought we were under Article 4 and that 120-day time period is what governed, the trial court below made findings on continuances. I didn't take those to be challenged by any party in this brief. And frankly, they're not particularly relevant given that the state is just timely proceeding here. That when the defendant moved to dismiss, we had not reached 180 days, so there is no need to consider.
But to the extent they are arguing that you were 1 day late and $1 short, perhaps, your argument to that is when they filed the motion to dismiss, that told the 180 days?
Absolutely, Your Honor. I didn't. When the defendant is actively litigating, is suggesting that my time period has already elapsed and trial court, you must dismiss my case, the state can't, during that time period, bring him to trial. We have to finish litigating his efforts to dismiss his case, which were brought prematurely. Before his time period ran, the defendant attempted to dismiss his case and lost. And then as soon as the day after that was dispensed with, the state brought him to trial. So I'd suggest to the court that the state timely, that even reading the record in sort of the light most favorable to the defendant, so we're avoiding any concerns about record ambiguity here. What the record demonstrates is that the state timely prosecuted the defendant under the IAD. Turning, Your Honors, to the sentencing range question, Your Honors, you're correct that yesterday I filed a notice of supplemental authority late last week in preparation for oral argument. I ran across the Guerin's opinion that my friend on the other side was discussing. And since I was going to be talking about it today, I wanted to bring it to the court's attention in a notice prior to argument. Your Honors, essentially the state's position here is that the defendant explicitly agreed below that he was a career offender. It's the second volume of the appellate record, page 22. The trial court asks the defendant and the state, so you agree that the only sentence that I can impose for certain Class D burglary convictions is a 12-year sentence at 60%. What the trial court is effectively asking there is, do you agree that Mr. Tomes is a career offender? And both counsel for the state and counsel for Mr. Tomes, with no ifs, ands, or buts, unequivocally say yes, that is the only sentence that can be imposed. There is no question in the mind of either party below that Mr. Tomes is a career offender. Of course, he now makes a different argument on appeal and challenges the sufficiency of sort of the state's documentation and evidence concerning certain convictions he had out of the state of Florida. Your Honors, the state's primary position here is this court should just conclude that the issue is waived, and in fact that this court should not engage in plain error review at all. That when a party sort of invites error by making an affirmative agreement, as was made below, and then attempts to sort of step back from that agreement, that is not a circumstance where it's appropriate to engage in plain error review. The parties both fully agreed as to where we were, as to Mr. Tomes' sentencing range, as to his offender classification. He shouldn't be allowed to change that affirmative agreement on appeal and then challenge it under plain error. So that would be my preliminary position. Secondarily, if this court does wish to engage in plain error review, I think defendant fails at perhaps the most common hurdle in plain error review, and that's he's failed to show there's a breach of a clear and unequivocal rule of law. Both for all the reasons I state in my brief, but also for the reason expounded on by Judge Greenholz in the Guerin's opinion. Trial courts have the authority under Tennessee Sentencing Act to accept agreements by the parties. as to certain facets of sentencing, including, I believe the statute is 4035-205, subsection D, explicitly gives trial courts the ability to accept agreements as to sentencing range, and that's all we have here. So the trial court accepts an agreement from the parties. It doesn't do any further investigation, admittedly, but it doesn't have to because it's not required to. It accepts the agreement. It has the statutory authorization to do that. It's not a breach of a clear and unequivocal rule of law. So even if this court engages in plain error review, which I don't think is necessary in this case, the defendant's claim still fails. Unless this court has further questions, I would ask that you affirm. Thank you, Your Honors.
Your Honors, I think I'd just take a brief moment to kind of clarify some things about this case. I think because the interstate agreement on detainers is so seldom seen, at least in our line of work, I guess, that it is important for this court to kind of address it in a substantive manner, not to knuckle wrap the trial courts for how they address something, but as an illustration of how things should go. The state is correct that in the trial court, we argued Article 4 applied, even though we now argue that Article 3 is applicable, the 180-day term. And I think the record here does show that it is Article 3 that applied. On page 5 of my reply brief, I cited to the record and included a picture of that record. It's volume 112 of the appellate record, and it shows that the form that was submitted and returned, at least signed by the Assistant District Attorney General that she received. The top says, prosecutor's acceptance of temporary custody offered in connection with a prisoner's request of disposition of a detainer. And please be advised that I accept temporary custody and that I propose to bring this person to trial on the indictment or complaint named in the offer within the time frame specified in Article 3A of the Agreement on Detainers. So I don't think that's really the burr in the saddle here. What's really going to be illustrative for this court is how to resolve this now that this is something that we have agreed to at the trial court level, and whether or not that error is going to be addressed or whether it needs to be addressed in light of the trial court's analysis on whether it was timely brought, that it did when it was determining the motion to dismiss. And in terms of that is the only reason that we mentioned the trial court's analysis on the continuances, whether or not that logic is still going to stand when it analyzed it under 120 days, and whether or not that's still good when this court examines or looks at it, and whether it was timely brought under a 180-day period if the court deems that that is what Mr. Tomes is entitled to.
One of the things I was thinking about with regard to the Garen's case that you just mentioned, that the parties agreed that he was a career offender, and then the court was allowed to rely upon that where you have two reasonable attorneys. So then the question becomes, in a case like the interstate agreement on detainers, when the two reasonable attorneys say it's under this article of the interstate agreement on detainers, is the judge responsible for going behind that to make his own determination, or can he rely upon what the lawyers say?
And that is an excellent point, and that was the point behind the decision in Garen's. What we would argue, which was the same thing that I argued when I argued Garen's, is even when we're looking at something like, say, jury instructions, there's a duty that the trial court has outside of what the parties represent to it. And that would be what we would rely on for that sort of similar framework in analyzing what the trial court is responsible for and what it's not responsible for when parties come before it. Because it can't just agree to everything that the parties come before it. It's got to do some kind of independent analysis to make sure they know what they're talking about. If there are no further questions.
I do have
Yes,
just
Judge
real
Wood.
quick. I'm sorry, Ms. Jones.
You're good.
The language in Article 3 on good cause for granted continuance is exactly the same as Article 4.
Yes.
So would the trial judge, would that matter? If that's the determination they're making, would there be any difference?
That'll be the question for this court, and that's the reason why I brought it up, not necessarily to analyze it, but whether or not that analysis that was conducted by the trial court for the 120-day time period is appropriate also for 180 day. And because the language is the same, this court could determine that it would be appropriate, or it could say, well, if it's 180 days and they've got a little bit more leeway, the continuance was, even though acquiesced to, that it might have been a different consideration. Thank you, Your Honors.
Okay, thank you. All right. Mr. Clerk, would you call the next case? Is everybody okay? All right. Would you call the next case, please?
Yes, sir. State of Tennessee.